document doesn't subject it to disclosure. So, the mere fact that something's attached to a public record doesn't also make it a public record. But interestingly, the court also found that the retirement agreement wasn't the final action resulting in a sergeant's discharge. This is based upon their definition of discharge. The court noted that discharge isn't defined by the right to know law, and that an employee's retirement is a voluntary resignation by his choice, while discharge is typically initiated by his employer. Thus, a decision to retire by agreement is not a discharge. This case might be relevant to you as an open records officer or a practitioner if you receive a request for someone's retirement agreement. Sometimes we're faced with arguments that the retirement agreement should be subject to access because it's the final action resulting in employee's discharge. But this Commonwealth Court case kind of clarifies that retirement isn't discharge.
Program ends at 11:30.
There we go. And the last reported opinion I wanted to cover, it deals with untimely appeals from the OOR. And in this case, Bethke versus City of Philadelphia, the request sought all policies from the sheriff's office. We granted, but the city, due to an error, failed to appeal the final determination within the statutory 30 days. The requester eventually filed for mandamus, seeking to have the court enforce our final determination. But the Court of Common Pleas directed the city to cross-appeal non-pro-tunc to address security concerns that the city had raised. However, the Commonwealth Court noted that, in an appeal of that order, noted that the failure to timely appeal the OOR's final determination requires an extraordinary circumstance, such as fraud, administrative breakdown, or some other circumstance unrelated to an agency's negligence. And a good quote from that case is, "It is the procedural circumstances, not the merits or perceived importance of the case, that must be extraordinary to warrant relief." So if you disagree with an OOR final determination, your statutory remedy is to appeal within 30 days. If you do not file that appeal within 30 days, it's a binding final order, and you're stuck with the ruling likely. So, if you disagree with the final determination, appeal. Our feelings will not be hurt. Okay, so here's, as I mentioned before, here's a listing of some unreported opinions. These are all from the Commonwealth Court. Unreported opinions from the Commonwealth Court are not binding precedent, but may be cited for their persuasive value. You'll see them cited in OOR final determinations occasionally. They're not cited as binding precedent, but for their persuasive value. The first one involves us, Duquette versus OOR. And in this case, an OOR appeals officer issued a final determination. The requester disagreed with certain actions taken by the appeals officer during the course of the appeal. And instead of filing an appeal of the final determination, they filed an action in Commonwealth Court seeking mandamus, declaratory, and injunctive relief against the OOR. We filed preliminary objections, and the court granted those because there was a failure of the requester to exhaust his statutory remedy. The court found that the requester's claims all stem from the OOR's issuance of its final determination, and that the requester could have obtained the requested relief by appealing the final determination to Common Pleas. This relief is adequate, as the right to know law provides requesters with a right to a de novo appeal. This means that the reviewing court is not bound by our findings of fact and can conduct their own fact finding. Therefore, the court found that the right to know law's provision of a statutory appeal is an adequate remedy to any aggrieved requester or agency. In this case, it goes to the sufficiency of evidence submitted to the OOR, Mack versus Pennsylvania Department of Corrections. The request sought, in part, a financial record, which the agency argued did not exist. On appeal, we received an affidavit from the open records officer explaining that another employee was likely to have such records, but had confirmed that she did not. We accepted that evidence as sufficient and denied that aspect of the appeal. But the Commonwealth Court found that this language was insufficiently certain to find that the records don't exist. The court took issue with the use of the word likely and noted that the fact that the agency located another record after claiming it did not exist should have alerted the OOR to question the veracity of the agency's evidence. I cite to this case just as a warning to anyone giving us evidence during the course of the appeal. Be careful with your words. Try to provide as much clarity as possible. Maybe don't say likely if you could be a little bit more definitive of that. But if there are instances where an agency says that a record doesn't exist and a requester comes back with evidence that it does, it's within the agency's best interest to try to clarify any ambiguity or questions that arise from that. Next case is Allegheny County Airport Authority versus Belco, and this case deals with severance payments. Specifically, it was a request for severance payments made to former employees of the authority. The agency tried to withhold that information. However, the Commonwealth Court found that past public expenditures are no different than current public expenditures. Importantly, there's no expectation of privacy in one's receipt of public funds. The court quoted a prior Supreme Court case involving Penn State, specifically quoting, "Any person desiring to keep his or her name and relevant financial data private should refuse Commonwealth disbursements. The public has a right to know how the Commonwealth spends its money." Based upon its analysis of prior Supreme Court case law, the Commonwealth Court granted access to the information, finding that the constitutional right to privacy did not apply. This case might be relevant if you have a case involving payments such as these, the right to privacy, or information concerning prior employees. I'll just go over this one briefly. There's not much analysis to hash out here. But in this case, in Re Mezzicappa, the Commonwealth Court granted access to mugshots taken at the county prison. The court ultimately found that mugshots aren't prohibited from being disclosed under CRIA, the Criminal History Record Information Act, and are also not exempt under the right to know law's investigative exemptions. Since it is an unreported opinion, the court didn't really get into the right to privacy or anything like that. But the case is worth consulting if you are dealing with a request for mugshots or something similar. And lastly, I wanted to go over this unreported opinion. This opinion is the lasted, I guess, in a series of opinions involving these parties, and it deals with a volunteer fire company, Peischer versus Clinton Township Volunteer Fire Company. This request sought various financial records, payments, loans, meeting minutes, and other financial records from the fire company. which denied the request because they maintained that they weren't a government agency. The volunteer fire companies aren't specifically made government agencies under the right to know law. This specific case applied a test previously set forth by the Commonwealth Court in an earlier Peischer opinion. This test is 3 parts. In order to determine whether an entity such as a volunteer fire company might be an agency, a local agency under the right to know law, we look to how much control the government has over the entity, how much public money the entity receives, and does the entity have a governmental purpose? When we applied this test, we found that the fire company wasn't an agency. However, the Court of Common Pleas ultimately reversed us, persuaded that the combination of the fire company's essential government function and the large volume of public funds made it an agency. The Commonwealth Court agreed with the trial court here. They emphasized that the public function of the fire company and the fact that the majority of the money was from municipal contracts. Before the trial courts, someone from the fire company actually admitted that it would cease to exist without government financial supports. Although the municipality does not formally appoint most of the members to the fire company, they nevertheless had significant power to audit or curtail the fire company. We're seeing a question. Are you seeing a greater frequency in appeals regarding volunteer fire companies? No, actually. We saw a greater frequency in appeals before we got this test. We haven't seen in the last couple months many volunteer fire company appeals, but I'm sure there's more along the way at some point based upon this case and prior cases stating that volunteer fire companies may be agencies, they may not be. It all depends on the facts of the case. This case's application isn't limited solely to volunteer fire companies. It's also relevant. What we have seen a greater frequency of over the past year are requests made to libraries. So this case might be relevant to whether a specific library is a government agency or not. If you ever want to look up any of these cases outside of this PowerPoint or look at some other right to know law related cases, we have an OOR case law index that's posted on our website. You can find that at the link posted. It's been recently updated to reflect the cases in this PowerPoint, but it has a ton of other cases too. It's not definitive by any means. There's a lot of right to know law cases out there, and we do our best to try to keep everything updated, but it might be worth consulting if you have any questions. If you have case-specific questions, we have an online docket search you can access on our website. There you'll find the final determinations as well as anything that happens subsequent to that. So you'll see court filings regarding that appeal. You'll see ultimate decisions. On the cases that go all the way up to the Supreme Court, you'll have all the appellate documents that go up all the way to there. So it's a good resource if you have any case-specific questions. And with that, I will turn it over to Nathan Byerly for his discussion on specificity. Thank you.
All right, we'll try to transition this over electronically, and I will make a couple clicks of buttons as we get transferred over here. All right, just going to double check that you can all see specificity and right to know law on your screen. All right, so we'll jump into this topic, which, as Liz mentioned early on, is everybody's favorite topic a lot of times. I know here at the Office of Open Records, we deal with the issue of specificity and whether or not a request is sufficiently specific on a constant basis. I don't know if it's daily that we discuss specificity in some context, but it's probably pretty close to daily. All right, I'm having problems advancing my slide here. There we go. All right, so before I get started, I'm going to give some disclaimers here. First off, this presentation is not legal advice and not binding authority, so do not cite this if you have final determinations that you're going to be handling, or appeals that you have, or requests that you make. This is just something to help walk through and be a assistance to all of you. Another warning, definitive answers may not always exist. Reasonable minds are going to differ sometimes on what a specific request, or whether it has that specificity that it needs. I look at these sometimes and think, you could have a situation where an appeals officer rules one way, a common pleas judge rules a totally different way in the context of the request. It goes up to Commonwealth Court, an en banc, and 7 judges have different viewpoints, and it goes up to the Supreme Court, and those 7 have different viewpoints. So some of this is going to involve just being a reasonable application of the case law that we have. And that's because the facts of each individual case are so important and are so distinguishing, and we look at these each as a case-by-case analysis. So now that you're sitting there thinking, okay, I'm not going to get any definitive answers, what's the point of this? I want to say that our goal here today is to give you some tips and tools to discuss some of these legal factors, to go over the 3-part test that the Commonwealth Court has developed and the OOR uses in determining whether or not a request is sufficiently specific, and then to also give you the ability to look at additional tools, additional resources, and to apply those to reach a reasonable conclusion, and I emphasize reasonable, as to whether or not a request is sufficiently specific. And if you're a requester listening today, to give you the ability to better draft reasonable requests. Again, emphasis on reasonable, that are sufficiently specific for the agency. And before we get started, I just, in looking at this issue, and maybe in the right to know law in general, is just to implore everyone to use common sense. I think we'll all kind of laugh at this one and say that, it seems to be a lost art in our world today. Additionally, is to be polite. Just common courtesy. We see more and more inappropriate and rude behavior, unfortunately, on both sides, agency and requester, and we just kind of ask everybody, let's just take a step back, treat everybody the way that we would like to be treated. Remember, we're dealing with other people's family members, and just to keep that in mind as we navigate, which, admittedly can be a sometimes frustrating process. And then related to common sense, let's not unnecessarily complicate the process. And you'll see what I mean as we talk about some of these cases where different situations have occurred where there has been an unnecessary complication of the process. But jumping into the law, and before we get going on some of the specific cases and the 3-part test, is what's the whole purpose? What's the whole point of this specificity and the use of this word sufficiently specific? And it's written right into the law, and it basically says that a request has to be made with sufficient specificity to enable the agency to ascertain which records are being requested. So in essence, the purpose of specificity is, do you know what the requester is requesting? Requester, have you made it clear what records and information you want? What is the info you're seeking? So that's basically the very starting point of all of this, is trying to ascertain what's been requested. Now, when a request comes in, the first response a lot of times by agencies is to look at it and go, whoa, this is going to be a ton of work. This is burdensome. I don't know how we're going to make this work. It's not specific enough. And burdensome and volume of the request alone does not make a request insufficiently specific. The courts have said it may be a factor, and we'll look at that as we work through that. A request may be sufficiently specific and even cover broad categories of records. The focus of the court has been a more broad viewpoint on this, and you'll see as we go through this, but broad categories are acceptable and have generally been found to be specific. Some other observations in the law: use of the word all does not necessarily make it automatically insufficiently specific. There are certain red flag words, all could be one, any and all, but not limited to. Those will raise specificity questions, but they themselves may not make it insufficiently specific. And at this point, I encourage requesters to use language that is as pointed and specific as possible. Don't leave it up to the doubt of the agency. So, including but not exclusively, including but not limited to, using of the word, I want similar records, I want something similar to this, or use of you use your discretion here, what's the authority you have. Those are all type of nebulous terms that leave the agency trying to guess what it is exactly and interpret exactly what you're trying to get. A note, too, is that a request can be partially specific. And this was in a case before the Commonwealth Court. You can give those records without waiving your ability to say, hey, the rest of the request lacks specific language and we can't figure out what they're asking for. And as you see there, the example was the person asked for records, files, or manuals or communications of any kind related to vehicle stops. And it was to the state police. So obviously, records related to vehicle stops is way too broad, but manuals was sufficiently specific. So keep that in mind as an agency as you work through maybe some of these more nebulous and broad type of requests where there's a lot of general language. You can still pick out specific types of records and respond to those and determine whether or not exemptions apply, which would be your next step. Just a word of caution, the courts have said if you completely rely upon arguing specificity before the Office of Open Records or even before the courts, and you don't raise any exemption, when it reaches the end, if you're wrong as the agency and the court says this is specific enough, it will be too late to raise any exemptions. It will be too late to redact those records. So keep that in mind, that you don't put all your eggs in one basket. You're going to want to be completely sure that if you're going to argue specificity, that this is definitely something that's insufficiently specific and not more related to maybe not wanting to have to go through a bunch of files to pull out the records, but that the request is genuinely lacking in specificity. So the Commonwealth Court developed a three-part balancing test in this Department of Education case. And they said there are three things that we need to look to as the Office of Open Records and you as agencies and requesters to determine whether or not a request is sufficiently specific. First off, there you have subject matter, second, scope of documents, and third, time frame. And the most fluid of them, as you can see there, being the time frame. And we're going to walk through each of these. But before we do that, I just want to jump up to the request and point out just a very quick analysis of this. So in this situation, the court looked at this, all of the emails of the acting secretary pertaining to the performance of her duties for basically a year. And you have in that situation, you have a type of document, emails, you have a finite time frame, but you don't have any subject matter. So pretty much they're asking for all the emails for a year. And the court said that is not sufficiently specific. And then they developed these standards and this three-part test. So walking through just in a little more detail what is met by each of the three parts of this test. First, subject matter. Describe a transaction, incident, activity, event, topic, action, or some agency business if you're a requester. So if you're a requester filing this, indicate what the subject matter of the request is. And agency, if you get an open-ended request that, there's just no guidance, it looks like it's asking for everything. Those are the type of situations that you are looking to deny for insufficient specificity. But an open-ended request, one that will be found to lack the sufficient specificity, is one that gives the agency really little guidance. It doesn't really give them any idea of what the requester is looking for. And in those situations, that is when the burdensome nature of it arises. We'll see it demonstrated here in a few minutes in some of these cases, but that will be considered overly broad. Another thing to remember in the subject matter part of the test is context is important. We'll see that in one of the cases. Don't, if there's a situation within your township or county, or there's some event that has occurred, or there is even some scandal that everybody knows about, and there's a request related to it, read it in the context of knowing that the situation that everybody knows about is what's being requested. Don't expand it beyond that. Don't go beyond, what everybody knows is being sought, and make it more convoluted than, or more broad than it's really intended to be. You shouldn't, as a requester, leave the, like I said earlier, leave the judgments up to the agency. It should be very clear, what the information you're seeking and what is related to that information. The documents relate to what, again, business action. The scope is it's pretty much just breaking down what type of record or what kind of record you're seeking. So you don't make a request saying, I want all these records. If you get like we said, you get a request for all the records, but be more specific. Looking for emails, reports, formal decisions, video footage. You'll see some of these other cases where they break down certain types of records that are being requested. Where possible, name the recipients and or senders of the emails. This isn't necessarily always required because obviously, as citizens in under a government, we're not going to know who's in what department. Sometimes we'll see requests that are specific enough for emails between certain departments. But again, be as specific as possible. And if you're the agency and are having questions about what's being requested or for what people, there's nothing that prevents you from reaching out to the requester. We actually encourage that to be done. Reach out, clarify what information the requester is seeking, and maybe even what recipients. And if they've maybe even misnamed the department that's handling a well-known project, follow up and clarify with the requester, hey, what's the emails that you're looking for, where there's a little bit of confusion here. And I, again, encourage requesters likewise to work with the agencies and give them that guidance that they're looking for, because many times the intent behind all of this is the efficiency of a government agency. There's no intent to hide things. They're just trying to use their resources in the best way possible. Time frame, the request should identify a finite period of time. That can obviously get to be lengthy, and you'll see my question there, how much time is too broad? And it really depends on the facts of the case. If there's no time frame given, sometimes there's enough detail within the scope and within the subject matter, like there's a well-known event that happened, it had a start date, a finish date, that could be looked upon as a contextual time frame. Basically, we come down to the same thing over and over again, and you're going to see this repeated, is does the request identify the documents with enough clarity for me as the open records officer to identify what they are? What if someone is seeking what if someone is seeking all records as defined under the right to know law? That doesn't specify the type of record in the request, but refers to the definition of record, which does identify types of records. Well, if you're seeking for all records, for an agency, the court's been pretty clear that that is not a sufficiently specific request. There's another thing too, that just because you ask a short time frame doesn't necessarily mean that it's automatically specific. So you could ask for, like exemplified, you could ask for all the agency's records from one day. That could potentially be not specific, but again, it depends on the facts. We would look at that on a case-by-case basis. If you have a very small agency, it could be that their records are not that many from one day. It could be any number of intervening facts that determine what the outcome in that case could be. One of the approaches that has been used is to use keywords to help make a request more specific. And in my estimation, I think most of the people here at the office would agree that, usually keywords add more confusion than clarity. But we see a good bit of cases that do have keywords. We expect to continue to see them, even though we encourage requesters not to use them. And just because you use keywords doesn't mean that your request is necessarily going to lack sufficient specificity, and just because you use keywords doesn't mean it's going to be a specific request. Again, the test is going to get applied to the keyword list, just like the test gets applied to any other right to know request. We have found keyword lists to be specific and not to be specific, and as Kyle mentioned earlier, you could review some of those final determinations in our final determination docket search. Unrelated kind of to specificity, just a heads up that when you do these searches, agencies know how to accurately and correctly run searches so that you can convey to the Office of Open Records or to the courts how vast a request may be. And we see from time to time that agencies are not familiar with their own systems, so they're unable to give an accurate or correct a summary of how many records or what search results are being brought back, or any number of other factors related to running searches that will help us determine whether or not there is sufficient specificity. So just a quick plug there to make sure you're knowing how to run some of those searches. So we're just going to jump into some case law. I'm going to walk through. These are court cases. Commonwealth Court has ruled on these. I have in the one column is the name of the case, and these cases are on our website. You can access them and read them if you want to follow up with them. I have the case name, then I have the actual request, whether or not it's specific, and why or why not. So on this first one, it's for police video footage. It's kind of a simple, I try to start with a simple one. It's for police video footage on a certain date of the requester and all activity of the department that day. It was appealed as not being specific enough. The court said, yes, it is, because the request identifies the subject matter, which is the department activity and video of the requester. It names the type or the scope, which is the video for surveillance footage itself. And it gives a specific time frame, 1 day. And there was also additional info in the borough's denial that reflected that the borough knew what footage was being requested and what footage was responsive. So that was a very clear example of a request that was sufficiently specific. OIG versus Brown is kind of the exact opposite of the previous case. The request was for the rules, regulations, policies, or related authority that governs OIG's duties and functions. And the court said this was not specific enough. And why was it not specific enough? Because it didn't provide any context. It didn't provide any subject matter. There's no category, no type of OIG activity, duty, transaction, business. There's nothing there to give the agency guidance except they want all these records that require us to make judgments as to what they're actually seeking. It also called for a legal conclusion, and I kind of warn requesters here when you're asking for, and this is very easy to get into these, when you're asking for what authority or what statute gives the agency authority, or what statute gives them the ability to exercise discretion, or why they exercise their discretion, you have crossed over the line into asking for records and information, and now you're asking for a legal conclusion, an interpretation, analysis, even an answer to questions. And the courts have consistently found that that type of approach is lacking in specificity. The court also noted it put an unreasonable burden on the OIG to try to figure out which rules, regulations, and policies would be responsive. Got some questions. Does your agency have that requires an address when a request is filed? We can talk about that at the end of that's unrelated to specificity. All right. If someone loses a case based on specificity, can they make another request with more specificity, or does the agency have the ability to deny the request because it had been made already? You always have the ability to file a second request for the same records. And if you lose on specificity, it just means you didn't ask a request specific enough, and you can come back and clarify with more specificity what you're seeking. Now, if they denied it based on exemptions and said, look, this is an investigative record, then you would have the ability to appeal to the Office of Open Records. And if you did not agree with that result, your remedy would not be to file another request asking for the same records again. You would want to appeal that to the Office of Open Records and have us look at the case to determine whether or not the agency appropriately denied your request. The next case we have is a Department of Corrections case, and we get one more step down the road as far as I think the complexity being demonstrated of specificity. This one, all records that document inmate injuries, and it was also for DOC employee injuries and deaths from January 2009 through December 2014. So basically 5 years of records related to injuries and deaths of inmates and DOC employees. And the court found that this was indeed specific. And I know sometimes people react, especially to this one, and say, wow, that's a lot of records. That's going to be a lot of work for the agency. And again, the emphasis was burdensome does not deem a request overbroad. So when you get a right to know request as an agency, right to know request as an agency, and you look at that, your first thought shouldn't be, oh, wow, this is going to be a lot of work. It must be insufficiently specific. Your first thought should be to go through the 3-part test, because burdensome, the amount of work, is not going to automatically make that overbroad. We're going to be looking to the 3-part test to determine that. So the court found that the request was sufficient because it informed the agency of the records requested. They knew what records were requested. They knew where to go get them because it was a clearly defined set of documents, that is, records that document injuries and deaths. It had a finite time period, 5 years, and that was sufficient in the court's eyes to make it a specific enough request for the agency to determine what records they needed to pull to be responsive. Now, even though it makes the records, you can find which records are responsive, you would still, as an agency, go through them and determine which ones would be exempt under the right to know law. So you'd still have the ability to raise your exemptions. If burdensome does not deem a request overbroad, can we request beyond the 30-day extension to the requester? Yes, and that's a great question, because we see cases. One particularly sticks in my mind. It was for literally terabytes of information, and the parties agreed. The requester agreed with the agency that they would have a rolling production of documents. But to make that work, it has to be in writing, and the requester will need to agree to it. There's also a process you can involve the OOR on. I'm not going to go into that here, but there are available, especially if you have, and it really is going to rely upon the requester many times. And I would say requester, if you are requesting voluminous documents, to work with your agency to set that up. But you can set that in a way that there's a continuance going forward. It's preserving the appeal rights of the requester, and the agency has the ability to give them the records, redact whatever they want. And at the end of that period, if there's disagreement over the redactions or stuff that has been withheld, then the requester still has the ability to challenge those exemptions or withholdings. And that preserves, everybody's rights and actually works at a much better process through that. But again, a lot of that is dependent upon having a requester that will be cooperative with the process. And the next case is the Philadelphia District Attorney's Office versus Bagwell. And this is a great case because it really breaks down a lot of the other relevant specificity cases that the court has ruled on. So if you were going to start with reading a case about sufficient specificity, I would start with this one. And if you get a request in and you're wondering about it, this is the case I would go to. And it was a lengthy request. I just pulled out one of the relevant parts to try to exemplify it. And you'll find that with some of these slides, the requests really go on and on. But all emails, letters, and memos pertaining to the transition from one email platform to another, was it specific enough? Yes. And again, seeks a clearly defined universe of documents. It's got the time frame date there. It's a year. It's got the scope. They want the emails. It's the type of record. Time frame is finite. Subject matter is the transition to the email platform. Carey versus DOC. This is that one I was talking about in reference with respect to context. There was a large inmate transfer. I don't know if it was a agreement between Pennsylvania and Michigan between 2008 and 2012, but there were inmates that were transferred back and forth between the two states, and one of the inmates filed a right to know request for documents and communications related to those transfers, and the court pointed out that the argument that all prisoner transfers was taking it too broad. It was very clear that they meant the transfers that occurred in relation to this agreement, and that DOC should have known what they were requesting based upon the context of the request. So this is one of those events where everybody knew what was going on, and that should have been applied to the right to know request to give it its sufficient specificity, because the agency should have known what records were being requested. Laguerre was another interesting one that was early on. This was a request for a certain type of record. I believe they're called Section 208 letters, where their determinations are made. And the Department of Education stored those records in individual files. And they said, and one of the defenses was, this isn't specific enough because we're going to have to go into each and every file and pull that letter out. They might have been even electronic. We'll have to pull it out of a database. So that's too burdensome. That's overly broad. And the court did not accept that argument. Again, pointing out burdensome does not equate to not specific. And the agency's method of tracking, catalog, storing, organizing their records should not be held against the requester. So if you have your records as an agency stored in a way that's going to make it difficult for you to access them, if a right to know request is filed, that will be on you as the agency. You're still going to need to provide access to public records. And as you can imagine, this has there's been a number of cases that we've dealt with databases, and how storage of public information in databases equates related to pulling that information out. That gets into a whole different discussion. But just because, again, it's going to take a lot of work for you to go into a database and pull information out is not necessarily in and of itself going to make a request insufficiently specific. So, how you retain your records and how you store them are very important decisions that you make on a daily basis, maybe even without thinking about it, because all it takes is one right to know request, and you could be on the hook for a lot of records. Montgomery County was a good keyword one. I'll point you to that. I'm getting a little short in my time here. The Engelkheimer case, another keyword case that would be helpful for you to look at if you're either get a keyword request or you're making a keyword request. Eastern Area School District ones, I wasn't planning on covering these two anyway. These were very early on, kind of more advanced in the approach that you can take to those, and you can look at those in your spare time if you want to have like a kind of a more advanced. We refer to these cases all the time as some of the foundational cases. Just tips to people, don't go on a fishing expedition. If you decide to go fishing, use the fishing pole instead of the broad net. Be specific in pointing your right to know request in the language you use. Be realistic in your expectations. Be willing to work with the agency. Ask yourself, is it better for me just to file a second, more specific request instead of filing an appeal based upon the timeframes that may be involved with the appeal, and you're wanting to get access to the records? And maybe you could be a little more specific in your request. And don't make discovery requests. We see this kind of regularly. Discoveries made for litigation. It's perfectly suited for litigation. It does not work so well on the right to know law side because it is just too broadly worded in probably 95%, if not more, of the situations that we see. Avoid using specificity. Just as a license to deny, if you're the agency, we see more and more agencies just tack this on as a quick argument. Avoid the temptation to wordsmith. I know we all do it. Common meaning of words. We had one come through where the agency said that the use of the word attachment in relation to emails was undefined and ambiguous. It's, the common term is, we all know what email attachments are, so we don't need to necessarily use that as an argument that this specific appeal lacks specificity. So, and then one more, avoid exaggerating the size of your request. We see this from time to time. A chain of emails, 25 emails with 25 different people copied, is still going to be 25 emails. That's not 625 emails and thousands of pages for us to print out. Let's keep it in a common sense approach to this. We've developed a specificity worksheet. It's going to be available on our website. It's going to be in the training section with these PowerPoints. I think they may even be there now. We're going to publish this on our web page as well in a more prominent way to hopefully help some agencies and some requesters work through what a specific request is. Like I said, this is all going to be available. I'm just kind of giving you a quick look at it. And then we have these additional resources. This will be on the PowerPoint. You can pull these up with the slides. We have webinar trainings, the case law, docket shirts, FAQs, how to file a request, and how to file an appeal. So with that, I'm going to turn it over to Kelly to talk about the portal. I'm going to let her get started, and then I will get her electronics up and running. Get this where we want it to be. There we go.
How do you advance the, let me see.
Arrow's right here.
Okay,
I've
great.
got this on. Let me get this up first. Is everybody see the portal presentation?
Can you see our slides, the new PowerPoint?
Yep. All right.
Thank you. Good morning. My name is Kelly Eisenberg, and as most of you are aware, July 1st, after about a year and a half of phased activation, on July 1st, we went live with our portal, our e-file appeal portal. It's our electronic system whereby the majority, with very limited exceptions, all of our appeals and anything that transpires during an appeal occurs through the appeal portal. What is it? We like to describe it as one-stop shopping for all your appeal needs at the OOR. It's a user-friendly online docketing and record management system, and it was designed to automate the right-to-know law appeal process. All appeals take place within the electronic portal, except in the event that an appeals officer needs to review records in camera, and the mediation process still will take place through emails. How does it work? Requesters use the electronic online appeal form to file their appeal. Agencies and requesters use the e-file portal to file evidence, arguments, and correspondence and communicate with the appeals officer. Once an appeal is docketed, a username and password is issued to the parties, and that username and password is required to access the e-file portal. You can share, for example, oftentimes an agency may have a legal counsel office, and they may want to share the ARRO's appeals, the ARRO's login credentials, but it's not advisable. We suggest that all participants obtain their own login credentials. One useful function is a user can track all appeals that they are involved with by viewing the list of active appeals that has pending, as well as any prior appeals. The OOR's administrative staff is always available for any technical difficulties or for guidance. Maybe it's your first time logging into the portal and you're having, some concerns or questions. The advantages. Solicitors and requester representatives can quickly and easily file an entry of appearance, and third parties, if it's applicable in that particular appeal, can request direct interest participant access. On the slide, you can see the link for our electronic forms to use those functions. And we suggest that you use the electronic forms because the individuals will be automatically granted user login credentials through the system as compared to us having the administrative staff reach out and issue the login credentials. The links make it easy for all parties to promptly view legal arguments, briefs, memos, affidavits, submissions, any kind of correspondence. This is what your your screen will look like when you go to the OOR website to log in to the e-file portal. You have the option to change your password if you prefer, or if you don't remember your password at some time in the future when you have another appeal. This screen shows you how you are able to change your password. There is on the login screen the reset password function. You click on it and it's similar to any other website that we are all familiar with in case we forget our website, forget our user login or password. This slide depicts the very user-friendly functions that are housed in the portal. The users can print a docket sheet that provides a summary of the important information relevant to the appeal, specifically what has the party names, their contact info, what has been posted to a particular docket, and the date when that was docketed. The other window shows a list of all appeals. When you log in, if you are a larger agency or you're a solicitor for a local agency, you will be able to access and view all of the appeals that you have previously been involved in and that are currently pending. This slide shows how you can submit a file from the docket sheet. You log in using your credentials, you click on the docket number and you'll access your docket sheet. You can see that you click the submit file button. Then a window will appear where you can, there's a drop-down menu with various document descriptions. Here's an example of some document descriptions. Request or correspondence, extension request, any kind of correspondence or submission in the appeal should be uploaded through the portal. And when it arrives in the portal, the appeals officer will receive an email alert that something's been submitted. It will be imported, and the parties will also receive a confirmation email with a description of what has been uploaded. Another option is there is a manual text file. This is similar to sending an email or a quick text message when you are for use when you're not uploading documents and you may have a quick inquiry. For example, ask the AO asking the appeals officer for a 5-day extension for your submission. Oh, there's a question. If the document description isn't correct, does that impact the decision? Not at all. Oftentimes, because it is a little, it may be a little confusing when you're a new user, the appeals officer will review the submission And we have the option of changing the description if need be. Otherwise, it is there. The electronic version of the document is on the docket sheet for everybody's review, and the description does not have any impact on the decision. This slide shows the examples of various types of emails you may receive during the course of an appeal. The first one shows what a party will receive once portal access has been granted. Portal access is automatically granted to the initial parties of the appeal. The requester and the agency open records officer is the typical case. For those of you concerned about security, only the parties that have been granted login credentials to an individual docket will have access to that docket and be able to view any of the submissions on the docket sheet. One exception to this is the final determination. Once it's posted, that will be a public document and is accessible through the OOR website. The second email alert shows you that a file has been uploaded, and it will have the description and the docket number, and you can click on those links to access that new upload. Please note that the system refreshes once per hour, so don't be concerned if you've uploaded a document and you don't get the immediate confirmation. You will receive something within the hour. And the final email alert shows you that there's a new appeal and new documents. We have recently made changes that have made them more detailed. We have highlighted that whether the upload is a brand new appeal that you should become aware of, and also includes the party names as well as the docket sheet. And otherwise, if it's just a new document that's been added, it will have the document description and the party names. And it will alert you that something has been submitted in a pending ongoing appeal. One note is the portal submissions are electronically time and date stamped. So you don't need to be concerned about timeliness if you make a submission before or after OOR regular business hours. We have a question. What if the person appealing does not use email? How do they get access to the documents? That's a great question. A typical scenario that we deal with are inmate requesters. The way it works is we receive paper mail. It is scanned into the system. It will be uploaded to the electronic docket sheet. However, the appeals officers proceed through our administrative staff to ensure that the inmate or other person without email or electronic access obtains a copy of whatever is posted to the docket sheet. This slide shows an example of a printed docket sheet. The users that have access to a particular appeal portal are able to either download or print out this docket summary. It's especially useful for your personal record keeping, and in the event that a party chooses to appeal the OOR's ruling to a higher appellate court, it is useful in creating a reproduced record for that court. And one note I want to make is sometimes there's some confusion about who needs to enter an appearance in the matter. The initial parties do not have to file an entry of appearance. That function is for agency representatives, for example, an agency solicitor, and sometimes a requester representative. Sometimes there are occasions when a requester will have counsel on appeal. And that would be also if there are interested DIP, direct interested participants that have been granted access as a party to the appeal. Any counsel for those entities would have to file an entry of appearance. And this needs to be done in each appeal. While you may be a solicitor for an agency and you've handled 10 appeals already, you still need to enter an appearance in every new appeal. That being said, your login credentials do not change every time. So there's no need to learn a new username and password for each appeal. However, you must fill out the electronic form so you're granted access to that new appeal. And that goes back to our security measures that only allow parties to an individual appeal to access the docket. This slide is OOR contact information. If anyone has technical difficulties or questions regarding how to use the portal, feel free to contact our admin staff, but there's also an electronic slideshow that is a more detailed version of this slideshow that gives you a step-by-step process to proceed through an appeal in the e-file portal. And that's all I have for this session.
All right, we'll open it up to questions now. If you have any general questions, feel free to type it in. Leave it open for a few minutes, and then if we don't get any, we'll just wrap up a little bit early. One thing I did want to alert everybody to, there was a major Sunshine Act case that came down late last week. It's posted in with the materials that were included for this PowerPoint. The name of the case was Coleman versus Parkland School District. So it relates to the Sunshine Act. So check on that. We're still analyzing it, but it's worth a look if you are a local agency that's subject to the Sunshine Act.
All right. This is Liz Wagenseller again, Executive Director. A couple questions that we got in. We'll get to some other from the chat. What are some of the most frequently requested and appeal types of records? I'm not sure about requested, but in terms of appeal categories, among state agencies, we get the most appeals involving the Department of Corrections. In terms of local agencies, it's been a change lately, just with what's been going on in the world. The counties and the school districts, we have seen a huge increase in their number of appeals because of issues related to the very high profile 2020 election in Pennsylvania, as well as the questions in school districts that you've seen in the news these days. Granted appeals and denied appeals most frequently, we don't really calculate that, but the type of records that tend to be granted, the bar is very, very high to prove an exemption, are financial records, invoices, and that types of things. You can redact certain information, but that's probably the records that we grant access to most of the time. Denied. On the flip side, the type of information that the bar is very high to have an exemption that is not applied are medical records. That it's I can't think of any situation if something is deemed truly to be a medical record, that would be something that we would grant access to. Okay, some specific questions come in.
Portal questions. On the appeals portal where it says check if no response, if the agency had responded that they received the request or made a 30-day extension, but never sent anything else past that, do we check that box or not?
Yes. If you did not receive a response from an agency, you would check that box.
And that would, and if they got a 30-day extension, the 30-day extension does not count as a response. Is that right?
Yes.
So let's see here. We check the box. So for an appeal based off my last question, if the person appealing does not really use email, do we, I'm assuming the agency, need to mail the agency submissions, or does the OOR take care of that?
No, you still as a, the agency, you have to discharge your, legal, your legal duty to serve all parties. So you should still mail it to that person. If we receive if a submission is uploaded, a correspondence is uploaded in the portal docket sheet, and we happen to notice that the, non-electronic, the person without electronic access has not been served, we will do it as a courtesy, but it's the party's legal duty, not the OOR's legal duty. We will mail the final determination or anything that the OOR uploads to the portal. For example, if we have a clarification question that we send to the agency, we will take care of that mailing to the person without access.
Do you only get a username and password to the new portal when you have your first appeal?
Yes, you have it, you get it, you'll be issued a username and password when you have your first appeal, and those login credentials will be good for any future appeal. If you have difficulty and you can't remember it or can't find it, feel free to reach out to the admin staff and they can assist you with getting new login credentials.
Now, I know you're able to go in and change your password in there as a user. Are you able to change your username as well?
I don't believe so.
Okay. Is there a limit to how often an agency can request extensions in general? An agency can only take the 30-day extension in response to a request. If they want to extend it beyond that, they need to ask the requester and reach an agreement with the requester to extend it beyond that 30 days. In general, if they keep taking extensions in response to other right to know requests, there's nothing in the law that precludes them from doing that as long as they're able to support it, or not support it, but as long as it falls within the reasons stated in the right to know law, which includes, legal review, staffing issues. There's a number of things listed that allow an agency to take extensions. Anything to add?
No, I mean, if you take too many extensions, it might be to your own detriment. If you then it just kicks the can down the road 30 days, you might have to respond to a bunch of hard requests all at the same time. So, I would strongly advise to only take extensions when needed.
Right. And if someone comes in and asks for a record that is typically easy to produce and provide, I would encourage agencies not to take a extension in that situation. Just, someone comes in and asks for a copy of a document that's sitting on a desk somewhere and it's just as easy as copying it, giving it to them. It may be worthwhile to not take the extension in that situation. But again, I know staffing limitations will impact things like that. Just operate in good faith. I use different email addresses for different agencies. Should I create an email address specific for the OOR so that all appeals are in the same portal, even though the agency would be contacting me on a different address?
Can you give me a little bit of clarification on that? Are you a requester or an agency that, or you're a requester and it depends on what agency you're making a request to?
Okay, we'll jump to
Yeah.
this next one, and then we'll see if we get a clarification on that. We use a portal to accept requests and still accept email and written. The portal uploads our records, letters, and affidavits. If we receive an email request, can we respond to the request using the portal that would send an email to the requester, or must we respond only via the email?
The portal that, the e-file portal that we use is only for appeals. I'm understanding your question to be at the request level at the agency. So we have no, there's no interaction and we have no, we have no contact with the parties when it's just at the request phase.
There's nothing prohibiting you from responding from within your own portal. It's an electronic means. The only thing I would advise is make sure that portal maintains a copy of your response. You have some duties under the right to know law to maintain that in your file.
Oh, it's their own, the question was, it's their own portal.
Yeah.
Yes.
So must they respond only via email? Okay.
Okay.
See Walt's.
I see. Thank you for the clarification, Walt. It's not necessary to create one just for the OOR. Just ensure that if you file an appeal, that you have the correct email address that you used with that agency. It should all match up. And recognize that you may have, that may result in multiple username and passwords because the appeals will be specific to the email address provided when you appeal.
Parkland School District.
Coleman versus Parkland School
Right,
District.
it's the Sunshine Act case, and that should be posted on the training section at the same place that these PowerPoints for this presentation today will be posted. So if you want to go read that.
All right, well, we'll wait to see if there's one more question. And while we are doing that, we are really excited because we've created a new position here. In government lingo, it's called Attorney One. We're calling it a law clerk, someone who's just graduated from law school and passed the bar. If you love the right to know law, or you know somebody who is a new attorney and would love the right to know law, feel free to reach out to us if they might be interested in applying for the position. Go one more minute to see if there's more questions. I don't seeing no activity. We're going to say goodbye. We have our regular trainings on Wednesdays. We have email, we have Twitter, we have all sorts of ways to reach out with questions. If you think we could do a deeper dive in one of these, let us know. We thank you all for coming, and we will see you soon. Take care.